The marble walls of the Supreme Court chamber echoed with tension as Congresswoman Jasmine Crockett stood before the 9 justices, her navy blue suit crisp against the rich mahogany podium. The C-SPAN cameras zoomed in as Justice Clarence Thomas leaned forward, his face stone-cold, serious. What happened next sent shockwaves through the entire legal world. Congresswoman Thomas said, his deep voice cutting through the chamber like a knife, "I've read your brief 3 times, and I must say, your understanding of constitutional law seems, elementary at best. Perhaps you should review the basics of legal interpretation before appearing before this court." The chamber fell silent. Reporters' fingers froze above their keyboards. The other 8 justices shifted uncomfortably in their high-backed chairs. But Crockett didn't flinch. Instead, her eyes narrowed slightly, her grip on her legal pad tightening as she reached for a folder her assistant had prepared. "Justice Thomas," she began, her voice steady despite the direct attack, "I appreciate your concern for my legal education. But in the next 5 minutes, I'm going to demonstrate exactly why your assessment is not only wrong, but dangerously misleading to the American people. No one could have predicted what would happen next." The research folder she opened contained evidence that would not only defend her legal expertise, but would turn Thomas's own judicial history against him in a way that left the senior justice speechless for perhaps the first time in his 30-year tenure. Before we dive deeper into this extraordinary confrontation, take a moment to like this video and subscribe to our channel for more breaking political analysis that you won't find anywhere else. Hit that notification bell to stay updated on the most dramatic moments in American politics. Justice Clarence Thomas sat in his center-right position on the bench, his imposing figure a testament to his 30-plus years on the nation's highest court. At 75, Thomas had become increasingly vocal and confrontational in recent years. Gone was the justice who once went years without asking questions during oral arguments. In his place was a bold, conservative anchor, unafraid to challenge anyone he believed lacked proper respect for his originalist interpretation of the Constitution. "The Constitution means what it meant when it was written," he had famously declared in a recent opinion, "not what some progressive lawyer wishes it meant today." For Thomas, this wasn't just another case. It was a challenge to the very foundational principles he had spent his judicial career defending. The voting rights case before the court carried immense implications for upcoming elections, and Thomas had clearly come prepared to battle. Across from him stood Congresswoman Jasmine Crockett, the 42-year-old former civil rights attorney from Dallas. In just her 2nd year in Congress, Crockett had already established herself as a rising star in Democratic politics. Her legal background included defending protesters, fighting voter suppression, and winning complex civil rights cases across Texas. Before entering Congress, she had built a reputation as a formidable courtroom presence who could simplify complex legal arguments for juries. Crockett had been invited to present arguments in this case because of her unique expertise on voting rights in southern states. She understood that she wasn't just representing her constituents but millions of voters whose access to the ballot box hung in the balance. "This isn't academic for me," she had told her staff while preparing. "I've seen voters turned away, polling places closed, and communities silenced. Justice Thomas might view this through constitutional theory, but I've witnessed the real-world consequences. The stakes couldn't have been higher." The case, Richardson v. Election Commission of Georgia, centered on new voter ID requirements that could potentially disenfranchise hundreds of thousands of voters, disproportionately affecting minority communities. Conservative justices, led by Thomas, seemed inclined to uphold the restrictions as necessary security measures. Liberal justices saw them as thinly veiled attempts at voter suppression. The tension in the courtroom was palpable even before the exchange began. Legal experts in the gallery whispered that the court appeared headed for a 5-4 split, with Thomas writing what would likely be a landmark majority opinion that could reshape American voting rights for decades. Thomas's dismissive comment wasn't just a personal jab. It was a signal that he intended to dismantle not only Crockett's arguments but her credibility as a legal authority altogether. By questioning her basic understanding of constitutional law, he was attempting to undermine everything she would present to the court. What Thomas didn't know was that Crockett had anticipated this very strategy. Her team had studied Thomas's increasingly confrontational style and prepared accordingly. The folder she now held contained something that would transform this routine Supreme Court argument into a moment that would be studied in law schools for generations. The chamber remained eerily silent as Crockett gathered her thoughts. Justice Elena Kagan glanced at her colleague Thomas with a raised eyebrow. Justice Ketanji Brown Jackson subtly straightened her posture, suddenly more attentive. Everyone sensed that something unprecedented was unfolding. Justice Thomas, Crockett continued, her voice growing stronger, I'd like to address your concern about my legal understanding by directly examining the constitutional principles at stake here. Thomas leaned back in his chair, a dismissive half-smile playing at his lips. Please proceed, Congresswoman. Educate us. The condescension in his tone was unmistakable. Several journalists in the press section exchanged glances. Thomas's increasingly combative approach had been noted in legal circles, but rarely had he been so openly dismissive of an attorney appearing before the court. The 14th Amendment's Equal Protection Clause and the 15th Amendment's protection of voting rights regardless of race form the constitutional foundation of my argument, Crockett began methodically. The Georgia law in question creates barriers that disproportionately impact certain communities, as evidenced by data on page 34 of my brief. Thomas cut her off sharply. Congresswoman, I'm well aware of what the amendments say. What you seem to misunderstand is that these amendments don't guarantee convenience. They guarantee equal treatment under the law. The Georgia statute treats all voters identically. Several conservative justices nodded in agreement. Justice Samuel Alito leaned toward his microphone. To follow up on Justice Thomas's point, where exactly in the Constitution do you find a right to vote without showing identification? The questioning was becoming a pile-on. Crockett stood firm, but the conservative bloc of the court seemed determined to dismantle her argument before she could fully present it. Respectfully, Justice Alito, the Constitution's protections extend to ensuring that facially neutral laws don't create discriminatory effects. The data clearly shows data can be manipulated, Congresswoman. Congress interrupted again. What can't be manipulated is the text of the Constitution, which says nothing about the specific procedures states use to verify voters. Perhaps this is the elementary distinction I was referring to earlier. A few muffled gasps came from the gallery. Thomas had doubled down on his criticism, essentially accusing Crockett of data manipulation. Chief Justice John Roberts shifted uncomfortably, concerned that the exchange was becoming too personal. Crockett took a deep breath. Her assistant silently slid another document her way. Statistical analyses from 3 independent research institutions confirming the disparate impact of the Georgia law. But she knew that data alone wouldn't counter Thomas's dismissive attitude. Justice Sonia Sotomayor attempted to redirect the conversation. Let's focus on the evidence presented in the brief regarding access issues in rural Georgia counties. With respect, Thomas cut in, addressing Sotomayor but keeping his eyes fixed on Crockett. I think we need to address the fundamental misunderstanding of constitutional principles before diving into county-level data. The Congresswoman seems to be advocating for results-oriented jurisprudence rather than textual fidelity. The tension in the room escalated further. What had begun as oral arguments in a significant voting rights case had transformed into a direct challenge to Crockett's legal credibility. Some observers later noted that Thomas seemed unusually fixated on discrediting Crockett personally, rather than merely challenging her legal arguments. Crockett glanced down at her notes, then up at the clock. She had limited time remaining, and Thomas's interruptions had consumed precious minutes. She needed to change the dynamic, and quickly. Justice Thomas, she said, her voice calm but resolute. You've questioned my understanding of constitutional principles several times now. I believe it's appropriate to directly address your concerns by examining how these principles have been applied historically by this very court. She opened the folder her team had prepared and extracted a document that her lead researcher had compiled over several late nights. It contained something that would shift the entire direction of the arguments. In preparing for today's arguments, my team and I analyzed every voting rights opinion you've authored or joined since your confirmation in 1991. We weren't looking for political positions, but rather for consistency in constitutional interpretation. Thomas's expression shifted almost imperceptibly. The other justices leaned forward, suddenly curious about where Crockett was heading with this unusual approach. What we found, Crockett continued, her confidence building, was a pattern that I'd like to discuss in relation to the case before us today. Particularly relevant is your concurring opinion in Shelby County v. Holder, where you argued that Section 5 of the Voting Rights Act was unconstitutional from its inception, not just in its current application. Thomas's jaw tightened. She was directly addressing his most controversial voting rights position. "I have the data here," Crockett said, holding up several pages of neatly organized charts. "And what it reveals about the consistency of constitutional interpretation might surprise everyone in this chamber." The room fell completely silent. Even the court reporters seemed to pause. Justice Thomas's earlier dismissiveness had vanished, replaced by an intense focus on the papers in Crockett's hand. "Congresswoman," Chief Justice Roberts interjected, checking the clock, "you have 10 minutes remaining for your argument." Crockett nodded gratefully. "Thank you, Mr. Chief Justice. That should be sufficient time to demonstrate exactly why Justice Thomas's assessment of my legal understanding is not only incorrect, but reveals a concerning pattern that this court should acknowledge." Thomas leaned forward, hands clasped tightly together. The confrontation had moved beyond a simple exchange of legal arguments. What Crockett was about to present would challenge not just Thomas's critique of her abilities, but his own judicial consistency over 3 decades on the bench. The stage was set for an extraordinary moment in Supreme Court history. Jasmine Crockett straightened her shoulders and approached the moment with measured confidence. The chamber was now completely silent. No shuffling papers, no whispered consultations among the justices' clerks. Even the typically restless press corps sat motionless. "Justice Thomas," Crockett began, her voice clear and steady, "you suggested my understanding of constitutional law is elementary. I'd like to respond by examining your own application of constitutional principles in voting rights cases." She placed a document on the podium, turning it so the justices could see the detailed timeline it contained. "This analysis tracks your opinions on voting rights cases from 1991 to present. What emerges is a pattern that's difficult to reconcile with the originalist principles you claim to consistently apply." Justice Thomas's expression remained impassive, but his fingers tapped lightly on the bench, a rare display of tension from the normally stoic justice. "In Crawford v. Marion County in 2008, you joined the opinion upholding Indiana's voter ID law, citing state interest in election integrity despite minimal evidence of actual fraud. Yet in your dissent in Arizona v. Intertribal Council in 2013, you argued state sovereignty should prevail over federal election regulations, effectively reversing your position on federal versus state authority." Crockett flipped to the next page. "But most revealing is this contradiction," she continued, her voice growing stronger. "In Shelby County v. Holder, you argued that the Voting Rights Act's pre-clearance requirement was unconstitutional because current data didn't justify treating states differently based on historical discrimination." She paused, making eye contact with Thomas directly. "Yet in your dissent just last term in Allen versus Milligan, you dismissed current data showing ongoing discrimination, arguing that the Voting Rights Act couldn't constitutionally address racial gerrymandering at all, effectively saying that neither historical nor current data matter, contradicting your own reasoning in Shelby County." A murmur rippled through the courtroom. Justice Kagan leaned forward with interest. Justice Kavanaugh glanced sideways at Thomas. "These contradictions reveal something important," Crockett said, her voice gaining momentum. "The inconsistency isn't in the Constitution's text, which remains unchanged. It's in the selective application of principles depending on the desired outcome." Thomas's face darkened. He leaned toward his microphone, but Chief Justice Roberts subtly raised a hand, a silent reminder about interrupting during a timed argument. "But I didn't come here today to simply critique," Crockett continued. "I came to defend voting rights. So let me connect this directly to our case." She held up a blue folder. "This contains sworn affidavits from 173 Georgia voters who were wrongfully prevented from casting ballots despite being eligible citizens. Among them is Mrs. Dorothy Wilson, an 86-year-old woman who has voted in every election since 1956, but was turned away because her married name on her ID didn't match her maiden name on ancient voter rolls." Crockett pulled out a photograph of an elderly black woman holding her voter registration card and driver's license. "Mrs. Wilson was born under Jim Crow laws, Justice Thomas. She marched with Dr. King, and in 2024, she was told by a poll worker that she couldn't vote because of a clerical error." Thomas's expression changed slightly, the first hint of emotion breaking through his judicial mask. The Constitution's meaning doesn't change, Justice Thomas, and we agree on that fundamental point. The 15th Amendment clearly states that the right to vote shall not be denied on account of race. When a law results in Mrs. Wilson and thousands like her being disenfranchised while voters in predominantly white districts face no such barriers, that's precisely what the founders sought to prevent. Crockett turned to address the full court now. My understanding of constitutional law isn't elementary. It's rooted in its actual application to real Americans. The Constitution wasn't written to be an abstract intellectual exercise. It was written to protect people like Mrs. Wilson. She deliberately placed the affidavits on the podium. And with respect, Justice Thomas, what's truly elementary is pretending that facially neutral laws with demonstrably discriminatory effects somehow honor the Constitution's text and meaning. The courtroom remained completely silent. Several justices were taking notes rapidly. Justice Jackson had a slight, almost imperceptible smile. Justice Alito looked uncomfortable. Thomas leaned forward, his earlier dismissiveness replaced by intense focus. "Congresswoman," he said, his tone notably different, "you suggest I've been inconsistent, but couldn't the same analysis show shifts in your own legal positions over time?" It was a genuine question, not a dismissal, the kind of engagement reserved for respected legal equals. Crockett nodded respectfully. "A fair question, Justice Thomas. My positions have indeed evolved as I've witnessed the real-world application of these laws. The difference is that I don't claim unwavering originalist consistency as the foundation of my legal philosophy. I openly acknowledge that seeing Mrs. Wilson turned away from her polling place informs my understanding of what the 15th Amendment protects." She gestured to the affidavits. "These aren't abstract theories. They're American citizens being denied their most fundamental right. If protecting their access to the ballot makes my legal understanding elementary, then perhaps we need more elementary thinking on this court." Thomas sat back, his expression unreadable but his earlier mockery completely gone. For perhaps the first time in his judicial career, he seemed momentarily at a loss for words. Chief Justice Roberts cleared his throat. "Your time has expired, Congresswoman Crockett. Thank you." As Crockett gathered her materials, a rare thing happened. Justice Ketanji Brown Jackson nodded slightly in her direction, a subtle but clear acknowledgement that reverberated through the chamber. Even more surprising, Justice Brett Kavanaugh leaned over to whisper something to Justice Barrett, both looking thoughtful rather than dismissive. The attorney for the state of Georgia approached the podium for rebuttal, but the energy had shifted dramatically. The confidence that had radiated from the conservative justices earlier had been replaced by a pensive uncertainty. What had begun as Thomas attempting to publicly diminish Crockett's legal credibility had transformed into something unexpected, a moment where a congresswoman had not only stood her ground, but had effectively challenged one of the most powerful jurists in America on his own terms, using his own words and decisions against him. As Crockett took her seat, reporters were already slipping out of the courtroom to file their stories. Whatever the eventual ruling would be, today's exchange had become the story, a story that would soon explode across every media platform in America. Within minutes of the Supreme Court session ending, the first tweets appeared. A CNN legal correspondent posted unprecedented. Rep. Crockett turns tables on Justice Thomas after he questioned her legal knowledge. Most direct challenge to a sitting justice I've seen in 20 years covering SCOTUS. By the time Crockett exited the Supreme Court building, her phone was buzzing continuously with notifications. The hashtags Crockett vs. Thomas and Elementary Mr. Thomas were already trending nationally. Cable news channels had dropped their planned segments to cover what commentators were calling a historic confrontation at the nation's highest court. Outside on the iconic marble steps, reporters swarmed around her. "Congresswoman, were you prepared for Justice Thomas to attack your legal credentials?" shouted one reporter. Crockett paused, choosing her words carefully. "I came prepared to defend voting rights, not my resume. But yes, my team anticipated challenging questions, and we prepared accordingly." Another reporter called out, "Do you think your exchange with Justice Thomas will influence the final decision?" "That's not for me to say," Crockett responded diplomatically. "Supreme Court justices base their decisions on constitutional principles, not on oral arguments. I simply presented the facts as I see them." But behind her measured public response, Crockett's team knew something significant had occurred. As they gathered in her congressional office later that afternoon, her chief legal advisor couldn't contain his excitement. "The clerk I spoke with said Thomas was completely silent during the conference, immediately after arguments," he told Crockett. "That never happens. He always leads with his position on voting cases." By evening, the video clips had gone viral. The moment when Crockett produced the timeline of Thomas's contradictory opinions had been viewed over 7 million times across platforms. Law professors were already assigning the transcript as required reading. Constitutional scholars from across the political spectrum weighed in, many acknowledging the effectiveness of Crockett's approach regardless of their position on the underlying case. Harvard Law professor Lawrence Tribe tweeted, "Whether you agree with her position or not, Crockett demonstrated masterful legal argumentation today. Using a justice's own words to challenge their consistency is advocacy of the highest order." Conservative legal commentator Jonathan Turley wrote in his blog, "While I disagree with her conclusions, Crockett's methodical presentation of Thomas's voting rights jurisprudence reveals a troubling pattern that originalists must address honestly." In newsrooms across America, producers scrambled to book experts who could explain the significance of the exchange to viewers. Fox News assembled a panel of conservative legal scholars, some defending Thomas while others acknowledged the effectiveness of Crockett's strategy. "She didn't attack him personally," noted one conservative commentator. "She attacked the consistency of his judicial philosophy using his own opinions. That's fair game, and frankly, it was brilliantly executed." On MSNBC, legal analyst Neil Katyal, who had argued dozens of cases before the Supreme Court, couldn't hide his amazement. "What we witnessed today was extraordinary. Supreme Court advocates spend their careers avoiding direct challenges to justices. Crockett not only confronted Justice Thomas's dismissive treatment, she methodically demonstrated contradictions in his judicial record that he couldn't easily dismiss." The White House carefully avoided direct comment, with the press secretary stating only that the president believes robust legal debate strengthens our democracy. Behind the scenes, however, sources reported that several calls had been made to Crockett's office from senior administration officials expressing private support. By the following morning, the story had made front pages nationwide. The New York Times headline read, "In rare Supreme Court confrontation, Congresswoman challenges Justice Thomas's consistency on voting rights." The Wall Street Journal went with, "Supreme drama, Crockett's methodical response to Thomas raises questions about judicial consistency." Law schools reported that applications mentioning an interest in voting rights law spiked dramatically in the weeks following. Several civil rights organizations noticed substantial increases in donations, with many contributors specifically citing Crockett's defense of Mrs. Wilson and others like her. For Crockett herself, the aftermath brought both opportunity and challenges. Interview requests flooded in from every major network. Constitutional law conferences sought her as a keynote speaker. Rumors began circulating that she was being considered for leadership positions within House Democrats' judiciary strategy teams. But with visibility came scrutiny. Conservative media began deep dives into her legal career, looking for contradictions or missteps. Security concerns prompted Capitol Police to increase patrols near her office after several threatening messages appeared online. 3 weeks after the oral arguments, as speculation about the court's eventual decision reached fever pitch, Crockett addressed a gathering of law students at Howard University Law School. "What happened in that courtroom wasn't about me or Justice Thomas," she told the packed auditorium. "It was about whether our legal system has the courage to look beyond theory to see how laws actually affect real people. It was about whether the Constitution is a living document that protects all Americans or just those with certain types of ID." A student raised her hand during the Q&A. "Do you think your exchange will change how Justice Thomas views voting rights cases?" Crockett smiled thoughtfully. "I don't expect to change Justice Thomas's judicial philosophy, but I do hope our exchange forces everyone on the court to confront the gap between constitutional theory and lived reality. Mrs. Wilson doesn't care about originalism or living constitutionalism. She cares about exercising her right to vote." Meanwhile, inside the Supreme Court, the justices were deliberating, According to sources who spoke anonymously to trusted court reporters, the initial vote had indeed been 5-4 along ideological lines, with Thomas assigned to write the majority opinion upholding Georgia's strict ID requirements. But something unusual happened during the drafting process. Thomas's first draft reportedly contained no reference to the statistical evidence Crockett had presented, focusing instead on abstract constitutional principles. Justice Barrett, sources claimed, sent a private memo questioning whether the opinion adequately addressed the documented disparate impact on minority voters. Justice Kavanaugh reportedly raised concerns about the public perception of ignoring the sworn affidavits of affected voters like Mrs. Wilson. When the court's decision was finally announced 2 months later, legal observers were stunned. In an unexpected 6-3 ruling, the court struck down key provisions of Georgia's voter ID law while upholding others, a nuanced decision that acknowledged both security concerns and access issues. Most surprising was the majority opinion, written by Chief Justice Roberts but joined by Thomas, along with the court's 3 liberal justices and Justices Barrett and Kavanaugh. The opinion specifically cited compelling evidence that certain provisions of the law create substantial and unnecessary barriers to voting that fall disproportionately on specific communities. In a rare concurring opinion spanning just 1 paragraph, Justice Thomas wrote, "While I maintain that the Constitution's text provides the ultimate guidance in these matters, I acknowledge that faithful application of constitutional principles requires careful consideration of their effects on citizens such as those who provided testimony in this case." The 15th Amendment's prohibition on denying the right to vote on account of race applies not just to laws that explicitly mention race, but also to those that achieve the same prohibited result through more subtle means. The evidence presented in this case demonstrates that certain provisions of the Georgia law fall into this latter category. Legal scholars immediately noted the significant shift from Thomas's previous positions, a shift that many attributed directly to his exchange with Crockett. 6 months later, when Crockett announced the formation of a new Voting Rights Institute focused on collecting and presenting data on voting access nationwide, donations poured in from across the country. The Institute's first hire was a full-time staff member dedicated to helping people like Mrs. Wilson navigate voting requirements and overcome administrative barriers. At the Institute's launch event, Crockett reflected on the lasting impact of her Supreme Court confrontation. Some people called it a victory when Justice Thomas joined that majority opinion, but the real victory belongs to Mrs. Wilson and the thousands like her who will now be able to vote without unnecessary obstacles. That's not a partisan win, it's an American win. As the midterm elections approached, voter registration drives across Georgia reported record numbers of participants, many specifically mentioning the Crockett case as their motivation for getting involved. And in a small church basement in rural Georgia, 87-year-old Dorothy Wilson addressed a group of first-time voters, holding up her newly issued voter ID card. "I've been voting since Eisenhower was president," she told them, and her voice strong despite her years. "And thanks to what happened in that courtroom, I'll keep voting as long as the good Lord keeps me on this earth." The confrontation that began with Justice Thomas mocking a congresswoman's legal skills had transformed into something far more significant, a moment that reminded America that behind every legal theory and constitutional debate are real people whose fundamental rights hang in the balance. For Crockett, the legacy wasn't about winning an argument with a Supreme Court justice. It was about ensuring that the Constitution's promises were kept for every American, regardless of where they lived or what ID they carried. As this story continues to shape American legal and political history, don't forget to like and subscribe to our channel for more in-depth analysis of the moments that define our democracy. Hit that notification bell to be the first to hear about major developments in voting rights cases nationwide. And leave a comment below sharing your thoughts on this historic confrontation between Justice Thomas and Congresswoman Crockett. Your voice matters in this ongoing conversation about the future of American democracy.